Hello everybody, and welcome to another episode of Foreclosure Help 777, where we discuss everything foreclosure related and share information to help homeowners better understand and defend their cases. First, I want to thank all of my subscribers for your support. If you have questions about your own foreclosure case, feel free to email me at foreclosurehelp777@gmail.com. As always, I'm not an attorney and cannot provide legal advice. I simply am a homeowner, just like many of you, who fought my own foreclosure case pro se. Through this channel, my goal is to share information, research, and real-world experiences so that homeowners can better understand the process and be better prepared to advocate for themselves. Okay, so let's get started. So today's topic is going to be standing firm in foreclosure defense by preparation. And today's Bible verse of the day is Ephesians 6:13, which says, "Therefore put on the full armor of God, so that when the day of evil comes, you may be able to stand your ground, and after you have done everything to stand." So a soldier does not wait until battle begins to put on armor. Likewise, a homeowner should not wait until the summary judgment hearing on foreclosure sale to begin preparing for defense. And you can see here, this is the whole, the armor of God. Let's get into how this pertains to foreclosure defense. Preparation begins before foreclosure. So many homeowners wait until the notice of default arrives, or the foreclosure complaint is filed, or the sale is scheduled. By then, valuable time may have been lost. Preparation often begins months or even years before foreclosure. So, the first thing to think about is to gather your evidence early. If something seems wrong, begin preserving your evidence. So examples would be misapplied mortgage payments, escrow shortages, unexplained fees, missing statements, servicing transfer issues, chain of title concerns, conflicting account balances. Do not assume that records will always remain available, because they don't. Build your evidence file. Important documents may include payment histories, monthly statements, default letters, notice of default, acceleration notices, mortgage statements, escrow analysis, loan modification documents, correspondence with the servicer, and don't forget about your taxes and insurance information as well, the escrow stuff. The time to organize these documents is before litigation begins, so ask questions early. If the account information does not make sense, consider requesting clarification from the servicer. So some examples again: payment history requests, account inquiries, error notices, or qualified written requests. A written request may help identify issues before litigation occurs. Create your own timeline. One of the most valuable tools is a chronology. Record payment dates, servicer transfers, default notices, modification applications, collection activity, foreclosure notices. A timeline often reveals inconsistencies that are difficult to see when reviewing individual documents. So the armor goes on before the battle. A soldier does not wait again till arrows are flying to put on his armor. Likewise, a homeowner should not wait until foreclosure litigation begins to gather records, preserve evidence, review account history, investigate title issues, organize important documents. Preparation starts long before the courtroom. So the armor of God, you have here a belt of truth. The litigation tool would be evidence. The breastplate would be credibility. The shield, defenses. The sword, legal arguments. The helmet is knowledge, and the shoes are preparation. So let's go over these. The belt of truth. Know the facts. A foreclosure defense begins with the file. Review the note, the mortgage, the assignments, the payment history, notices, loan modifications. Without the facts, there is no defense. The breastplate of credibility. Protect your credibility at all costs. In foreclosure defense, credibility matters. Judges evaluate accuracy, consistency, honesty, professionalism, reliability. A litigant who is viewed as credible is often more persuasive than a litigant who is not. How credibility is earned. Credibility is built through accurate statements, truthful representations, proper citations, organized exhibits, meeting deadlines, following court rules, professional conduct. Your reputation before the court develops throughout the case. How credibility is lost. Credibility can be damaged by misrepresenting facts, exaggerating claims, filing unsupported allegations, ignoring court orders, missing deadlines, making arguments without evidence, attacking opposing counsel personally. One inaccurate statement can undermine many valid arguments. Let the documents speak. Strong litigants do not rely solely on accusations. Instead, they present payment records, discovery responses, assignments, correspondence, admissions, and testimony. The evidence should carry the argument. The helmet of knowledge. Learn the rules and understand court rules, local rules, deadlines, discovery procedures, motion practice. Most cases are lost because litigants do not know the rules. The shield of evidence. Gather your proof. Collect your letters and your statements, your payment records, emails, discovery responses, admissions. Evidence locked in a filing cabinet protects no one. Evidence properly presented to the court becomes part of the defense. Evidence stops arguments the same way a shield stops arrows. The sword of the law. Know your legal arguments. Potential issues would be standing, conditions precedent, statute of limitations, RESPA, FDCPA, TILA, breach of contract. The legal argument is only effective when it's supported by facts, not legal conclusions, but facts. Shoes of preparation. Stay ready and prepare. Get your chronologies, your exhibit list, your discovery requests, your witness questions, your hearing outlines. Preparation creates confidence. The bank is prepared. The plaintiff usually arrives with attorneys, servicers, document custodians, payment histories, witnesses, litigation experience. The homeowner should prepare accordingly. And also, prepare a hearing script if you have a hearing. Never assume you will remember everything during a hearing. Courts can be stressful. Judges ask unexpected questions. Opposing counsel may interrupt your train of thought. A written script helps keep you focused. What should the hearing script include? A good hearing outline may contain an introduction where you state your name, state who you represent, state the purpose of the hearing. And the main points, you want to have like some issues. Main points, issue 1, 2, and 3. Supporting evidence. If you have exhibit references, discovery responses, admissions, and case law. Requested relief. What are you asking the court to do? The script is your roadmap. A hearing script helps you stay organized, stay on topic, avoid forgetting key points, present facts logically, respond more confidently. The goal is not to read every word. The goal is to have a roadmap. So practice before hearing. Read the script out loud. Time yourself. Anticipate questions. Identify weak areas. Revise as needed. The more familiar you are with your presentation, the more comfortable that the court will be. Preparation does not end when the brief is filed. Preparation continues until the hearing begins. Prepare before filing the motion. Many litigants think preparation begins when they draft the motion. In reality, preparation begins weeks earlier. Example: if you're doing preparation for a motion to compel discovery, the other side serves boilerplate responses such as overly broad, unduly burdensome, irrelevant, subject to and without waiving objections. The temptation is to immediately file a motion to compel, but preparation comes first. Build the record before filing. Before filing the motion, you want to send a conferral email. Explain the deficiencies. Request supplementation. Follow up if no response. Allow reasonable time to respond, and keep copies of all communications. The goal is to create a record showing you attempted to resolve the dispute without court intervention. Your exhibits begin before the motion. A strong motion to compel may already have exhibits before it is even drafted. Here's an example. Exhibit A would be the first conferral email. Exhibit B, the second follow-up email. Exhibit C, the third follow-up email. Exhibit D is plaintiff's refusal to supplement. By the time the motion is filed and the evidence of your efforts is already organized, think 3 steps ahead. Successful litigants often prepare the motion before the motion exists. Ask, if I have to file this motion later, what evidence will I wish I had? Then start gathering it now. Preparation today creates stronger motions tomorrow. Judges notice preparation. Imagine 2 motions to compel. Motion compel number 1. The responses are inadequate. No exhibits, no conferral efforts, no documentation. Motion number 2. Defendant sent 3 conferral letters on March 1st, March 15th, and March 30th. Plaintiff refused to supplement despite repeated requests. Attached exhibits, documented efforts, clear chronology. Which motion is more persuasive? Foreclosure defense is not magic. Successful cases are usually built through research, documentation, discovery, persistence, preparation. Victory rarely comes from a single argument. It comes from building a complete record. Okay, so having done all, stand when the motion is filed, when the hearing is scheduled, when the summary judgment is argued. The question becomes, have you prepared? If you have, you may not control the outcome, however, but you will know that you stood your ground and you did the best you can, and that's what matters. Okay, guys, that does it for today's episode, and if you have questions, you can always send them and put them in the comment section below, or you can join me on my Facebook page, which looks exactly like this one, Foreclosure Help 777, and I hope everyone has a blessed day.